Florida has recently enacted an expansion of police authority in regards to immigration enforcement, and this is what you need to know as a citizen or visitor to the state. Florida Governor Ron DeSantis has been known for actively directing his state law enforcement agencies to form ties with the U.S. Immigration and Customs Enforcement, also known as ICE. DeSantis stated his aim being to enhance Florida's capacity to enforce federal immigration laws and subsequently increase the removal of undocumented immigrants. However, while the state appears to seek consistent enforcement standards, local law enforcement agencies could be faced with a vast array of responses from the local community, as well as it potentially leading to a patchwork of enforcement practices across the state. Leading us to Senate Bill 2C and Senate Bill 4C, both signed into law in February of 2025 and are built upon previous immigration-related legislation. Senate Bill 2C consists of measures designed to strengthen Florida's involvement in immigration enforcement, including provisions regarding the eligibility of non-U.S. citizens' rights to vote, restrictions on the issuance of driver's licenses to individuals without lawful immigration statuses, and the establishment of a state board of immigration enforcement. This bill also allocates over $298 million to support the implementation and execution of these enhanced enforcement activities. While Senate Bill 4C follows a more direct approach by creating new state-level crimes related to the entry and re-entry of people who have entered the state and are suspected to have come into the country illegally. We will be speaking about Juan Carlos Lopez Gomez in a moment. Classifies this act as a first-degree misdemeanor and subsequent violations being classified as third-degree felonies. Lastly, Senate Bill 4C mandates the imposition of the death penalty of quote-unquote unauthorized aliens. Now, besides Senate Bill 2C and 4C, Florida has also expanded its involvement in immigration enforcement through the federal 287G program, a federal program authorized by law which allows ICE to enter into formal agreements with state and local law enforcement agencies delegating specific immigration enforcement powers to officers who have received appropriate training. A number of law enforcement agencies across the state have already signed and are preparing to sign this agreement. Now, let's talk about Gomez, one of the victims of Senate Bill 4C. In April of 2025, Gomez, a 20-year-old U.S. citizen born in Georgia, was arrested in Florida following the signing of Senate Bill 4C in February. Gomez was detained during a traffic stop on a Wednesday. His mother presented Gomez's birth certificate to the court the following day on a Thursday, and a judge found no probable cause for the arrest. However, could not release Gomez due to the judge having no jurisdiction, and Gomez continued to be detained under ICE's request. Later on that evening, while at a protest, Gomez's mother received a phone call from ICE informing her that Gomez was being released and to meet at a nearby Wendy's. Now let's further discuss Florida's participation in the 287G program, which expands the authority of state and local law enforcement agencies in regards to immigration enforcement. Florida law enforcement traditionally focuses on enforcing state-level criminal law. However, this program grants the right to inquire into matters traditionally handled by federal statutes by granting the authority to trained officers to interrogate people about their immigration status, as well as Florida Highway Patrol troopers now possessing the power to perform many of the functions that are typically performed by federal immigration officers, such as questioning persons on their legal right to be present in the United States. Furthermore, this program could lead to increased scrutiny of persons based on the perception of their immigration status during routine law enforcement encounters. The 287G program also grants the authority to Florida officers to detain persons they suspect may be in violation of federal immigration laws and expands to a variety of law enforcement interactions, such as traffic stops. Florida officers can now serve and execute warrants for immigration violations, and Florida Highway Patrol troopers can execute federal immigration warrants. Lastly, Florida officers deputized under the 287G program are granted the authority to administer oaths, collect evidence, conduct interviews, prepare affidavits for ICE review, and issue immigration detainers, which are official requests to hold individuals in custody while federal immigration authorities assess their immigration status and the potential for removal. Moving on, it's time to discuss the significant implications the new immigration laws in Florida has on its residents, starting with the heightened risk of encounters with law enforcement officers who are now granted the right to inquire about an individual's immigration status during a vast array of law enforcement interactions, from those in public settings to a simple traffic stop. This could lead to a feeling of unease within local immigrant communities, with fears of being profiled based on appearance, accent, or location. This fear is not unwarranted either, given the recently discussed case of Juan Lopez Gomez. This fear could severely impact the lives of many immigrant people by hindering their ability to travel freely within the state, gain services such as healthcare, and maintain employment, thus exacerbating the existing labor shortages in key areas of the state's economy that rely on immigrant work, such as agriculture, construction, and hospitality. Furthermore, this could result in even more arrests, deportations, and separations of families, thus further traumatizing the communities around them. All in all, the new laws in Florida and their implications and potential to create fear within the most vulnerable communities who have established lives in Florida raise ethical and humanitarian concerns. And while officials state that the objective is to enforce immigration laws, the consequences on long term residents warrant careful consideration. Those planning to travel to Florida for summer vacation, especially those who may appear to be of foreign descent or non US citizens, should be aware of the implications of the recently discussed new immigration laws in Florida prior to potential interactions with Florida law enforcement. International tourists should also consider the current immigration climate in Florida when making travel plans, due to the fact that routine interactions with law enforcement could lead to questions on the traveler's immigration status. If those choose to continue their journey to Florida, it is imperative to carry valid identification and documentation that clearly proves their legal entry into and current status within the United States of America, including passport, visa, or other relevant immigration forms. If one is questioned on their immigration status by a law enforcement officer, you have the right to remain silent and are not legally obligated to answer questions about your immigration history or the manner in which you entered the country, as well as it being important to avoid providing any false or misleading information. And if detained, a visitor to the country has the right to contact their country's consulate or embassy for assistance. Furthermore, these new policies could have a negative impact on Florida's tourism industry, which is the cornerstone of Florida's economy. Now that we have fully discussed Senate Bill 2C and 4C, plus the 287G program and their implications to Florida residents and visitors, now it is time to fully understand your options and rights. In order to better protect yourself, always carry valid identification and relevant immigration documentation. Thoroughly document encounters with law enforcement when you feel your rights are being violated, and seek legal advice from a qualified immigrant attorney, and connect with your local immigrant advocacy organization for valuable resources and more information on your rights. While visitors should always carry their passport and visa if required, or other official documentation that serves as proof of legal entry and current status. Always carry contact information for your country's embassy or consulate if you're a non US citizen. And lastly, if you're unsure of your rights, it is best to politely inform the officer that you wish to remain silent and request to speak with an attorney or your consulate. As for your rights, you have the right to remain silent and to refuse answering questions about immigration status or entry. You have the right to refuse search unless a valid warrant or probable cause is present. You have the right to contact your consulate if you are a non US citizen. And remember the importance of truthfulness by providing truthful information to law enforcement officers. Thank you for sticking with me on this topic. Shoot me a follow and come back for more. Thank you.